Hi, my name's Steve Bartlett, and welcome to Fight Back. If you're noticing the set looking a little bit different than it normally looks, I have an explanation for that. It's at the same studio, but this studio actually had a flood, and as a result of this, things had to be moved around as repairs are being done. And this is my first show back since that happened, so I wish my producer all the luck in the world in getting this place reorganized. But this is actually kind of cool. It looks like I'm at the Hard Rock Cafe or something with all this memorabilia everywhere. But so welcome back to the show. And things are a little bit strange today. We don't have this typical high tech that we normally have. I got a microphone actually right here that you can actually see. And because of my work schedule, I really don't know what I'm going to be talking about too much in detail today. Normally I like to do some research and come up with some facts and everything, have a little bit of notes, but today I have even less than I normally have because I've been just working since 9 o'clock this morning, going to court and dealing with clients and doing what lawyers basically do. But welcome to the show. I'm glad you're actually here. Now, like I just said, I'm an attorney, and like all attorneys, I went to law school, and I went to law school up north, even though I live in Florida. And I had a buddy who I knew back in undergrad who was coming down to Florida to go to Key West. And he called me up and says, hey, you want to go to Key West with me? And we went down to Key West and had a great time, drinking, partying, playing with jet skis, water skiing. We had a great time. And he actually was a landlord, and he said to me, hey, I got a house up north outside of the college. Why don't you come move in with me, and we'll have a good time your last year of law school. Now, the first 2 years of law school, I lived either on campus or right near campus. But my last year of law school, after I knew I was going to graduate and I got it all down, I actually lived in downtown in the city where I was going to law school. And it was really fun because there's an area where I went to law school, which is really similar here in Florida to Ybor City, which is an area where they have all these bars, and it's a historic district, and it's really nice. It's really cool. And that's where I actually lived when I was in law school, actually in this historic district. And it was fantastic. I had the best time of my life. We went out, my one roommate was a bartender, and my best friend in law school was a bartender at one of the bars at that historic district. And they would give me the best pours. I give them $5, and they'd have me drink all night. It was fantastic. The name of the law school that I went to is the University of Dayton in Dayton, Ohio, and which I used to call the Harvard of Dayton. Because, you know, I was saying that flippantly, even though it is a really good law school. But where I lived was a place called the Oregon District in my last year of law school, and that's the historic district in Dayton. And last week, when I woke up, I read that Dayton had a mass shooting. And not just any part of Dayton, but the Oregon District, where I actually lived for a year of my life, was where the mass shooting was. And most nights, especially my last year of law school, I was at one of the bars having a beer or drinking a scotch or a bourbon or whatever at one of the bars that my buddies were tending bar at. And the one bar was called the Night Owl. It was a jazz club. It was fantastic. And that's where the shooting occurred, right outside of that. If I would still have been in law school, if I was still up in Dayton, Ohio, there's a strong, not just a strong chance, but a strong probability that I would have been present during the shooting. I may not have been killed, but I would have been there. And I know a lot of people who still live in Dayton. I have a lot of my best friends live in Dayton, Ohio, and I feel so bad for that community. And I can't imagine what it must feel like to be a college student, you know, going out to have a beer after school whenever you hear a car backfire, hitting the deck thinking that it's a mass shooting. And last year, I dedicated, I think, about 15 shows of Fight Back about gun violence. And I try to explore it in every possible way that I can think of. And I explored the different problems with the gun laws and different methods of trying to curb gun violence. And I think I did a very thorough job after the shooting down in Parkland. I said, I'm not going to just do a 30-minute show about gun violence. I'm going to talk and talk and talk until there's nothing else to say. And I was hoping that that would be the end of it, and I wouldn't need to come back and do another show. But unfortunately, we had two shootings last week, one in El Paso and the next day in Dayton. And it's getting worse. People are dying of mass shootings and it's become insane. And political leaders really haven't done much to fix it. A lot of my episodes were talking about the power of the NRA and how they use the ability to give people money to try to stop any type of legislation that could curb gun violence, because when more people die, profits actually go up for the gun manufacturers. And because of that, I cynically said that we're not going to really have a change or an end to gun violence because of this power that the NRA has with the power of the purse to affect at least the Republican Party, and a lot of Democrats too, from supporting any type of legislation that could be considered to be gun control. However, this last shooting, things may actually be changing, at least in the state of Florida, which is an extremely conservative state. It's had a governor most of the years that I've lived here. The legislature has been Republican, both the House and the Senate up in Tallahassee for many years. And yet, after this tragedy occurred, the activists got together and they actually passed legislation in the state of Florida dealing with gun violence. And the name of the statute is named after the school, and it's a very all-encompassing statute. It actually adds a lot of language in different areas. Parts of it are controversial, like arming teachers in schools and stuff like that. But that's not what I'm talking to you about today. I'm talking to you specifically about one statute in Florida which was created after the deaths in Parkland, and that's statute 790.401, which is about risk protection orders. Now, even though that's what the statute says, that they're risk protection orders, what they're called commonly nationwide are red flag laws. And Florida has the most famous red flag law in the country. And the Florida red flag law is now actually a model that's been proposed by Marco Rubio in the Senate this year. And I hate to say this, and anybody watching this show who knows me will say that they couldn't believe what I'm about to say, but President Donald Trump, after these two tragic shootings that just occurred, has said that he supports and he's willing to battle against Republicans and the NRA about enacting federal red flag laws, so making something like the risk protection orders that are in Florida nationwide. Now, as you know, I am not a big fan of Donald Trump, but I have to take my hat off to him. If he does anything to try to reduce gun violence, other than the old standby, we need more guns, let's give everybody a gun to reduce gun violence, but actually do something that has the support of those who are activists trying to stop gun violence, I've got to take my hat off to him. Now, these might be empty words. Mitch McConnell refuses to put the Senate back in session, and who knows what he's going to do when he comes back. He's promised that he's going to try to tackle the issue of gun violence and take up at least discussing these red flag laws. But I wouldn't hold my breath, because we're talking about Mitch McConnell. And even though I'm giving props to Donald Trump, and I hope he follows through on this promise, based upon his history and his repeated flip-flopping, many times even in a single day, by the time I get home tonight, I might have found out that Trump has changed his mind and he's no longer in favor of red flag laws. However, as of right now, he is, and I am actually grateful. And it's like, thank you, President Donald Trump, for actually listening and at least promising to do the right thing. But yesterday, I was at home, or 2 days ago, I don't remember exactly. I think it was 2 days ago. I was watching on the internet my friend Andre Rocks, who is a activist living in Pasco County, who actually has a show as well similar to mine, and he was talking about red flag laws. And he's a liberal, and I agree with him. He's a progressive in politics, and we agree about a lot of things. But on the show, he was saying why he was opposed to red flag laws. I wanted him to be on the show tonight, and I promised him that I would be calling him today, but because of the technical issues, I found out when I arrived at the studio that I would not be able to call him and have him on the show. But I listened to his show, and he raised a lot of cool issues that I think are important, but I want to actually address some of those issues and concerns, because maybe I can change his mind and persuade him, because I think his opposition of the red flag laws is misguided. So these red flag laws, what they actually do is if somebody is considered to be, dangerous, it allows a petition to be filed with the court to temporarily prevent them from owning a firearm. Okay? Now, the only person who can actually file this request for a risk protection order is law enforcement in the state of Florida. So generally, if a person is concerned about a relative and they want to, and they're scared that this person could be a mass shooter, they have to contact law enforcement, and it's actually law enforcement who actually files the petition for the risk protection order in the state of Florida, not an actual individual citizen. That's what the law is right now in the state of Florida, but currently there is actually legislation pending in Florida to amend it to allow for family members of a potential mass shooter to actually petition the court without the need to actually go through law enforcement to do this. That's also how the federal law that Marco Rubio proposed in Congress is actually written as well. So changing the law in Florida to allow any individual to petition the court if they think there's a need for a risk protection order. Now, what does it need to say in this risk protection order when you're petitioning the court? Well, let me go through it with you. I actually have the statute right here. It's a long statute. I'm going to go through some of the highlights if I can. But it actually says that the person filing the petition has to show that the respondent, that's the person who you want to restrict the ability to own a gun, poses, and this is important, a significant danger of causing personal injury to himself or herself by having a firearm or any ammunition in his or her custody or control, or by purchasing, possessing, or receiving a firearm or any ammunition. And it must be accompanied by an affidavit made under oath stating the facts that give rise to a reasonable fear of significant dangerous acts by the respondent. The key words is that it has to be significant danger. Significant danger, not a remote chance that the person may be able to do something. It has to be significant, it has to be dangerous, and it has to be reasonable, based upon reasonable fear. Who decides this? A judge. Okay? So right now what would happen is a person would file this petition stating that there's significant danger of an act being done by the person who they want to restrict their gun ownership, okay? And then that gets filed with the judge. Once the judge looks at that, okay, and it's under oath by law enforcement, and if they change the law, it will be under oath by whoever's filing it, okay? Once the judge looks at that, if the judge thinks that based upon the affidavit, there's a need to protect society from this person, the judge can issue a temporary order requiring the person to surrender his weapons temporarily for 14 days. Only 14 days, okay? Now, this is legal. People say, doesn't that violate due process? No, it doesn't. They can actually have a domestic violence injunction, kick you out of your own house, stop you from seeing your kids under the same process. It's not a violation of due process if it's only for a short period of time and you have a right to have a hearing. And that's what it requires. After 14 days, you have a right to have a hearing and dispute the allegations. And the judge will take testimony and listen to any evidence that you present and what the other side presents. And then the judge, if you win that hearing, you get your gun rights back. If you lose the hearing, then the judge can restrict your right to own a gun for no more than 1 year. After 1 year's over, you can go back in front of the judge and ask for your gun rights to be restored and have another hearing. And you can do that every year if the judge decides to enact it for another year. So it's not meant to permanently take away someone's right to own a gun, only when they're in a crisis situation. Now, they can go less than 1 year if they want to, if they think it can be resolved quicker than that. But the point is, when someone's in crisis and it can be proven to be dangerous, to limit their ability to have a gun temporarily until they can look at the matter more closely, okay? Now, what's the burden of proof? Now, as you know, in a criminal case, in order to put someone in jail, the burden of proof is proof beyond all reasonable doubt, which is the highest standard that needs to be done. If you're suing somebody for $1 million, however, or pretty much every lawsuit, all you have to do is show by a preponderance of the evidence in order to prevail. However, in order for this law to apply, in order for them to restrict your right to own a gun, it's a different standard somewhere in between. less than beyond all reasonable doubt, but a lot higher than a preponderance of the evidence. And that's called clear and convincing evidence. So the only way the judge can deny a person's ability to own a gun is if the court finds by clear and convincing evidence that the person poses a significant danger of causing personal injury to himself or others. Okay? So it has to be, it's a high burden, it's hard to do. It's not something that people can do half-ass or haphazardly. Okay? It's something that's very, very difficult. And the judge will look at certain factors to decide whether or not to actually grant this. Here are the factors that the judge looks at as to whether or not someone poses a significant risk of causing harm. Whether or not the person is seriously mentally ill or having recurring mental health issues. Being a little depressed, being a little blue is not the same thing as being seriously mentally ill. Another type of evidence that the judge looks at is whether there was a recent act or threat of violence by the respondent against himself or against somebody else. An act or a threat of violence by the respondent within the past 12 months, including but not limited to acts of threats or violence by the respondent against himself or others. Now, people might say, well, can't a restraining order do the same thing? Because if a restraining order is entered against you, you lose your right to own a gun. Well, what happens if the person who the violence was committed against is afraid to follow the restraining order? Okay, if that person's afraid to follow the restraining order, the person's a danger, then there's no protection. This allows another individual or law enforcement, if the person is a violent risk to anybody or the public in general or even to themselves, to file this petition. Other things that the court can consider is whether or not there's ever been any previous risk protection orders ever issued against the person, whether or not there's ever been a violation of any risk protection orders, whether or not a previous or existing risk protection order was ever issued, whether I've already talked about those, whether the respondent has ever been convicted of a crime that constitutes domestic violence, whether the respondent has used or threatened himself or anybody else with weapons. So another reason why you would need this order when you couldn't do a Baker Act. Baker Act is when somebody is involuntarily placed in a mental hospital for evaluation. If a person doesn't make a specific threat to hurt themselves or others, okay, but is making general threats or making general statements, they may not be able to have their liberty stripped by being placed in a mental hospital temporarily, but even though they don't meet criteria for a Baker Act, this will allow them to not have guns until they can get to the bottom of things, okay? And currently under the law in Florida, just because a person does get placed under a Baker Act for 72 hours of evaluation, they can still keep their guns during that evaluation. This law makes it so that while the person has been placed in a mental hospital and has already had their liberty taken away temporarily before they have their right to have a hearing or released from 72 hours, this way it makes sure that they don't have any weapons so that when they get out, they don't just go, postal. Other things are evidence of abuse of controlled substances. If you're a drug addict, that's a factor that the court can actually look at to determine whether or not there is a clear and convincing evidence of posing a significant danger to yourself or others. Whether or not you just purchased a bunch of firearms and a bunch of ammunition is another factor that the court can actually look at. So when the judge enters this order, the point of it isn't to punish people or turn them into criminals. The point is to try to get them help so that there's no longer a need to actually have this restriction on these people. So the court, when they enter the order taking their guns from them, can order that the person receive a mental health evaluation or a chemical dependency evaluation if they think it's appropriate. So let's say there's concern that you could be a danger, that you're mentally ill. You can be ordered to see a psychologist or a psychiatrist. If the evaluation shows that you're fine, then you'll be able to then the judge will get your guns back. Okay, so there are laws there that are there to actually help people get their guns back once they are found to be fine and not a danger to anybody. So 14 days is not going to let someone die because they don't have their gun for 14 days. I don't know of anybody who's ever been subject to removal of this gun who died because they weren't able to protect themselves during those 14 days, okay? And this is able to make sure that they get help before you give their guns back. And you have, like I said, you have an absolute right to have a hearing every year if you want to, if the judge does grant it for a year. There are other provisions in here that people who actually are fans of guns Well, actually, like right now, if there's a restraining order against you, if you have a domestic violence injunction against you, you have to surrender your guns. And it's a real pain in the ass for people, once the injunction is no longer in effect, to get their guns back, because their guns are taken by law enforcement, and then it's so hard for people to get their guns back. What this statute does is, once this temporary order is no longer in effect, it requires law enforcement to immediately return your guns. So even if your guns are taken temporarily, soon as this injunction goes away, you get your guns back that same day. Also, right now, police officers are the only ones who file these affidavits. It makes it a felony to file a law to lie in these affidavits. So if the police officer tries to be racist or try to do something that is illegal or unethical, they can end up going to prison for overstepping their boundaries and lying on these restraining orders. Okay. The other thing that is cool about it is, as opposed to giving the firearms to law enforcement, you have the ability to actually give it to a family member or somebody that you trust, as long as they're able to legally possess a gun. So as long as you don't actually have these guns in your possession, you don't have to turn them over to law enforcement. You can give them over to anybody. Okay? And like I said, it's a felony if you lie on these affidavits. So if anybody who's a family member has a vendetta against another family member and files it, if they change the law to allow that, then what will happen is, if they lie, they are being exposed to going to prison for perjury. Okay? Now, how good are these laws? What's the point of these laws? Are they actually any good? Are they effective? Well, since this law went into effect, there's been almost 2,500 of these protection orders that have been actually entered in the state of Florida. The person who was in charge of assessing the risks after the shooting in the high school down at Stoneman, Douglas, was actually the sheriff of Pinellas County, Galtieri, who's actually the sheriff in Pinellas County, and he's a Republican. He's very well respected. And a lot of these ideas for these red flag laws actually came from him. And he even commented that the shooter in Parkland had all of these signs that he could actually do something dangerous and could actually hurt the community and actually be dangerous. But there was nothing specifically that allowed him to be Baker acted or to have an injunction against him without this new law. And he was confident, based upon the warning signs that he had, that if this law were in effect, the Parkland shooting never would have occurred. That's not according to some hippie liberal like me. This is according to the Republican sheriff of Pinellas County. Okay? To quote him, he said, "It's a huge step towards greater public safety in ensuring that people who shouldn't have arms and shouldn't be able to purchase firearms don't do so." Okay, this is from the sheriff himself. That's what he's actually said. Now, currently, there's actually a proposal by the Republicans in the Florida legislature to actually repeal this law, to go backwards. After this horrible shooting occurred, they're trying to get rid of these red flag laws because of money and funding by the NRA. Now, my friend Andre Rocks, I wanted to address this. He's afraid that African Americans will be targeted by this and that they will actually lose their rights. However, like I said, any type of lying is a felony punishable by prison. And there is due process protection here because you have a right to go in front of the judge. Okay? And currently there already has been a large conspiracy against African Americans to deprive them of their rights to own a gun. If you look at how many African Americans compared to whites are actually convicted of felonies, when you're a convicted felon, you lose your right to own a gun. That's how African Americans have been disarmed and mistreated in this country, because a lot of them have been convicted of felonies for crimes that should not have been felonies and have been singled out and have been victims of racism. And so the African American community have already lost their ability to own guns. But you know what? Currently, there are too many guns, not only in the white community, but the African American community as well. And is it really a bad thing if somebody is a danger to say that this person temporarily cannot have a gun until we actually have a hearing to make sure they're not a danger? And then if it turns out they're not a danger, give them their gun back immediately. Okay? I think that's going to save lives. According to According to the sheriff of Pinellas County, he talks about several different cases, and he says that lives have been saved here in Pinellas County where people have made racist threats of violence against other people, where there has been people, a teenager was talking about how fun and addicting it would be to shoot people. Legally, there would be no other recourse to actually protect society because of that. But this law allows that. This law stopped this teenager from being able to shoot up a school. The construction workers who were African American who were threatened that his wife was going to get killed by a racist. This racist took his gun away temporarily so he could get the mental health that he needs to stop a racial shooting. So we need to stick together, and we all need to learn how to fight back. I will see you next week on Fight Back with Steve Bartlett. Sorry about the look of the set, but man, I'm so proud of the fact that they got me up and running, and I'll talk to you next time. Let's end this insanity and end gun violence. See you next time. Bye.